My name is Jason Lazarus, founder of Synergy. With me is Teresa Kenyon, Synergy's head lien resolution subject matter expert and vice president of lien resolution. She's a California and Kentucky licensed attorney and is a seasoned professional with expertise in ERISA, FEBA, the Medicare Secondary Payer Act, and private healthcare lien resolution. With an incredible amount of lien resolution experience and almost 8 years spent at Rawlings, she's a wealth of subject matter knowledge from both sides. Under her leadership, the lien resolution team at Synergy resolves thousands of liens each year, saving injured parties almost $100 million each year. She is so passionate about our mission of improving the life of injured parties and helping their families by protecting the net recovery. Teresa, for personal injury law firms, there are many complexities to consider when you're dealing with all the different potential types of liens they'll face: ERISA, Medicare, Medicaid, FEBA, military, et cetera. Can you succinctly talk about all of the different lien types and their own key considerations?
Yeah, definitely. I mean, all the lien types, right? Like that's just that there are a lot and they are all different. So key to all of them is to make sure you get that claim summary and you are auditing those claims and making sure that what is on there and what is being asserted as a lien is appropriate, proper, and accurate for your case. So often things are just there that shouldn't be. So you always want to make sure you're starting with the accurate, correct number. But otherwise, I'm going to just kind of go through like lien type by lien type. So for ERISA, a lot of liens are ERISA liens, right? Like those are just those employer-based health plans. And the key to those is making sure you have the proper plan language, the policy documents, the master plan, and the summary plan. These lien holders are going to give you the summary plan, and those are changed year over year, and they're able to perfect them and make them be as friendly to them as they want them to be. But the master plan is sometimes only created every 5 years or 10 years. And ultimately, the courts have said that that is the document that really matters. So you got to make sure you have the right documents on these ERISA plans. And if you're not, then you're starting from a wrong place and you're on the wrong foot. So that's definitely the key for an ERISA plan. For Medicare, traditional Medicare through CMS, again, auditing those claims, super, super important. Hardship arguments are important to them as well. They obviously automatically will apply a procurement reduction, but don't just be okay with that. Know that you can still put forward some arguments and get it below the procurement reduction. Another key to Medicare is making sure that you're identifying an advantage plan that also might exist. So a lot of times people will think that there is no Medicare lien or there is a Medicare lien, but it's not actually capturing all the claims. So those Medicare Advantage liens are out there and they're hidden is what we say, but they are handled by private insurers, and the subrogation vendors that handle them are all very different in how they engage with those plans. You should identify them first and then make sure that they are applying the procurement reduction. Certain vendors won't. They have other arguments that they put forward on why they don't have to reduce. And so that is a whole separate fight. But the key is to make sure that you are getting the procurement on the advantage plans as well. Medicaid is a big lien type that we see here at Synergy, and also has private vendors that are handling those. So they can become complicated to identify on the front end because there are state agencies that are handling it, but also the private vendors, and sometimes both if people have different types of plans at different periods of time during their treatment time. So Allborn is the big case that's out there to be applied. Different vendors, different states, all are going to apply it differently. So there's lots of interaction that takes place on those liens. So making sure that there's a full awareness of which law applies, how to best argue the hardship that comes with it, whether or not you should talk about futures or not. Those are all key considerations for the Medicaid and the Medicaid MCOs that are handled by those private insurers. Military liens. So this is TRICARE and VA. They are big on hardship. So telling the story is often where we see the biggest moves, but also having relationships with the people that are making those decisions. So that's really the key for the military liens, is making sure that you've identified the appropriate facility, or and it can get confusing with the VA, because it is very facility based. But otherwise, telling the hardship story is what gets you the reduction in that relationship with the person on the other side. Then we've got hospital liens and provider liens. So two different ways that those should be approached. If there is plenty of settlement funds to technically pay that bill, you've got to start by seeing that that bill is just a made-up number and that there should otherwise be a reasonable value that should be paid for that particular claim. And so often the bill is just outrageously high. That should never be your starting point. That should almost mean nothing to you, the bill itself. Now, meanwhile, when there's not enough settlement funds, and it is, for example, a $50,000 settlement, but you got a $100,000 hospital bill, you're going to make more of an equitable argument. Again, back to the hardship with the hospital or the provider. Often find that the hospitals are not quite as empathetic. And I think it's just because they're a hospital that everybody that's in there is sick and injured and receiving treatment. So it's the hardship doesn't go quite as far with a hospital as it does with the other lien types. And I think I'm trying to like rack my mind of a list, but I think that's a good number of those liens that we handle and just kind of the quick hits.
Well, if you take nothing away from all that as a trial lawyer, thinking about all these different types of liens and the different considerations and the different strategies, knowing how to handle all of that, the inside baseball is what Teresa's team of experts knows how to expertly navigate. So instead of dealing with lien headaches, if you want to save your firm time and money, consider partnering with Synergy to outsource lien resolution to the experts.